So, good afternoon, good day, good evening, everyone. If you're joining in live or whenever you will actually watch this video on my YouTube channel and on LinkedIn, welcome to our second online event for my South African University Mediation Enthusiasts Mentorship Group. Yes, that's kind of a mouthful, but I named it that for a reason. It's to get law students, any student really, law graduates interested and enthusiastic about mediation, and for it to the group to be a safe space where we don't get this topic addressed, and there's no avenue and there's no space for it at university. So if you're excited about mediation or you are starting to get excited, then the group is for you. And of course, all of the events we will have and the program that's to follow next year is going to be geared towards you, right? So today I'm very pleased to have my colleagues in the house, some of which I've met for the first time in getting them to speak at this event, and I'm very privileged to have them. Naazneen Khan, Karen Botha, and Justine Del Monte. So thank you so much for speaking today, and you will hear from each of them in turn on their different topics. We want to make this as fun, as conversational. We want to be enthusiastic, right? That's part of the group name. So we want to sound lively and not lecture you and sound boring. Okay. And the objective of the session is to get you as the law student, law graduate, even maybe a young candidate attorney, interested in what's going on the ground in terms of the various pilot projects, mediation pilot projects taking place within different parts of the judicial system. And of course, most, if not all, of my colleagues here are based in Cape Town. So you might hear a bit of Cape Town bias, but I love Cape Town, so that's cool. But we want you to ultimately, at the end of the session, not just to get excited about what's getting done, but also reach out to our panelists afterwards, so that for you to get involved. Get because once you actually get on the ground and see it working, you see mediation working at your local magistrate's court if they happen to run a pilot project, you actually feel better in the case turnover, in that you can sit and mediate three matters in an afternoon, maybe even on a Friday, and you'll feel fulfilled as opposed to rolling over those same matters for the next court appearance, right? And I've heard so well from students where, or even candidate attorneys who participated in pilot projects, to say how fulfilling it feels to be part of it, right? So the whole aim here is for you to get involved, and of course to connect better with our speakers after the event, right? So I'm going to let the panelists introduce themselves at the risk of, or so as not to risk missing out anything in their illustrious CVs. I'm going to get them to briefly introduce themselves, and then I will start with my topic. Okay, I think Nazanin, you can go first.
Who's going first?
Yeah, I
Naz.
guess I'm going first
Okay,
since
Naz.
I'm at the top here. Hi guys, my name is Naazneen Khan. I am an attorney at BPG Incorporated in Pretoria, Gauteng, by the way. So I don't know about you guys in Cape Town, but we are in one of the best areas in South Africa. And yeah, very biased. I'm also a partner with Karen Botha at Dignified Dispute Resolution, which is actually a pilot project that started just over a year ago. And yeah, very passionate about mediation, very passionate about helping mediation start from grassroots level, because I think that's actually what is needed. And I'm happy that we're having this discussion today, which I'd like to thank Lisa for, because these conversations are very important, and these conversations actually need to take place not just once, many, many times until it sticks.
Thanks, Nazanin. Karen?
Right, I'm Karen Botha. I'm an attorney. I am in Cape Town, originally from KZN, and moved to Cape Town 3 years ago. I specialize in family law, and that is what drove my passion for mediation, because in family law it's so emotional, and there's so much going on. Because litigation takes such a long time, mediation is a far better option for people to take in order to resolve conflicts, especially when there are long-term relationships that are going to be involved. So I'm actually a commercial mediator. I qualified through conflict dynamics, but also a family mediator. I'm very passionate about mediation. As Naz said, we started an organization called Dignified Dispute Resolution, and we want one of our main visions is for mediation to become mainstream, which at the moment it isn't. It's very bitty. And yeah, that's going to be the legacy that Naz and I intend to leave in this world.
Yes.
I just want to add that one of our slogan or our catchphrases are educate, empower, support. So this is actually being on this video is actually something that is part of our vision.
Excellent. Yes, Karen wants to contribute.
Yeah, Justine can go ahead now.
Okay.
Awesome, thanks. So I'm Justine Del Monte. I'm also an attorney, admitted practicing 20 years. I studied at TICS, so had the benefit of having that. And they had a alternate dispute resolution elective when I was final year student. So that's where it started for me. It was something that I was interested in, and I could take that as an elective at the university. At the same time, I also took as an elective advanced labor law because that was something I was interested in, and human rights law. And so I'm putting that into practice. I have my own practice in Cape Town. We just do employment law. And that's obviously where the mediation aspect then came in, those two combining. And, we've got the CCMA, which is conciliation, mediation, and arbitration, labor court. So mediation's always been part of the kind of law that we practice, but it's not everything. Have we lost Lisa?
I'm not sure. She's gone blank.
Yeah. Shall we stop? Shall we continue?
I don't know. Well, let's just continue. I'm sure she'll come back.
Okay, well, I've got the two of you. I'll chat to you.
Yeah,
So that's where it is. And what I would be interested to hear from you, I know, sorry, I'm taking over, but the whole idea of family law, particularly Corin, which you dealing, and I've also just attended a discussion also organized by Conflict Dynamics, because I was also did my commercial mediation training through them, is there's this idea that it's only for family law and employment law because it's soft law. And that was actually the topic that they were speaking about, which I think as practitioners, you and I know that labor and family law is anything but soft.
Yeah, I think, yeah. I mean, that's why I did commercial mediation, not just family mediation, because it's any dispute essentially can be mediated. So it doesn't matter if you're having an argument with your neighbor about, my kid kicked a ball over your wall and broke your garden gnome, and now you're upset. You can mediate that. Or you've got a contract between two companies and there's a dispute with regards to the contract. It can be mediated. And 100%. I think that is one of the most important things that people seem to misconstrue about mediation, is that it's limited to, like you say, labor disputes because of the CCMA and family disputes because it's soft.
It's soft. 100%. And I mean, mediation, as we know as practitioners, it's so versatile. It can be used in so many respects. As you said, neighborhood disputes, things like that, but also even, we were discussing it, the negotiation of contracts. I know Bonnie or Don did an article on that. I don't know if you saw it, where it would be useful to have a trained mediator who's completely impartial, has no vested interest, to get those two big parties who are trying to negotiate a big deal, just to assist them in that. And I think that's maybe where we're lacking is, as you said, Corin, it's that understanding of what a mediator actually is there to do and what our training is there for us to do.
That's 100%.
Yeah, absolutely.
Like, back in the day, sorry, I think there's a slight lag. About a year ago, if you put in mediation into Google, for example, you used to come up with not mediation, but what would come up was meditation. If I put in mediation,
I think you still do sometimes.
yeah, if you put Bing scenario, Bing images, when you want them to create or imagine an image, and you want to like give me an image of people mediating a dispute, and then there's people sitting in suits meditating. It's actually like super weird. And then there's a lot of misconception about what mediation is, but I think we've made a lot of headway in the last year with regards to mediation, because now when I Google mediation, things of mediation do come up. But another misconception of mediation is that it's negotiation, and that's something Karen and I discussed as well on another thing. That what courts do is they'll send you outside to try and mediate your matter outside the court, and then come back into court. But what happens is nothing happens, because people misconstrue mediation for negotiation. And they also misconstrue the fact that, like you said, it's so versatile. You don't necessarily have to be involved in some kind of litigation to be able to resolve a dispute. So yeah, I think
100%.
it's something. Yeah.
Yeah. And in our practice, we are using mediation, just to jump in, just to give another example. For workplace grievances, you can mediate that. I've had a matter which showed that mediation is extremely powerful. The employer was like, these two parties are never going to be able to work together. We're going to lose two valuable employees. It's a disaster. Everything's coming. And one's lodged a grievance against the other, and they didn't even contemplate that know what mediation was. They didn't know what a grievance process was either. But they said, no way is this going to work. And with someone just speaking to the individuals and following that process and creating that safe space where people could talk and just open up, it was resolved to the shock of everyone. And it's just, I think also individuals who, as you said, they think it's like this, we're all meditating in a circle and we're all going to, kumbaya, and everything's going to, kind of work out. But they don't understand the power of mediation, because very few people have actually experienced mediation, because there's still not a big take up on it.
No,
Yeah,
and I
I
think
think
one of the
that's
reasons.
sorry, Naz. What I think the biggest issue really is that people, like Naz says, you get to court, you finally get to court for your day at trial, and the court says, even a judge or magistrate say, go outside, go and settle this. And people think that that is mediation. And that's not mediation. That is the worst time, in fact, to be attempting mediation or a negotiation, because the parties by then are so polarized, and they actually negotiating from a place of fear. Whereas mediation enables, like you say, it gives them a safe space to express all the underlying feelings. We look at the principle of the iceberg, and the 10% that's above the water that we can actually see. That's actually also usually what the parties can see, because that's what they're experiencing. But they haven't come to grips with what's below the surface and is actually causing the dispute. Yeah, so
100%.
I think that's where the power of mediation is. And we
Yeah,
never
and
learn conflict resolution. It's not something we learn.
well, not as attorneys, we don't learn that, because we taught that it's adversarial and there's nothing else. I know at varsity. And as an attorney, when I started, I was like, am I going to be an attorney? Because it's all about fighting, and that's not in my nature. I want to solve problems. But I don't know if it's just women. I don't know. Are there guys who believe that as well?
No, it is. It's very bad. Because I think one of the things that we need to also address with attorneys, like I think Karen and I also always say, coming from a background of litigation is your bread and butter. So to actually resolve a dispute by an outside person that's getting this money now, it takes away a lot from our table. However, what attorneys don't realize, and they're looking at it in the wrong aspect, is that a client coming to you to litigate, their matter is taking years to litigate. That client will never consider litigating another matter or bringing you as an attorney another matter ever again, because they feel that their matter is not going to get resolved. But this is how mediators can actually enhance the services of another attorney or another litigant, because if a litigant gives a party justice quicker, that client will come to you again and again to resolve their problems. Why? Because you managed to get them justice quicker than 10 years. So I think they're very short-sighted. Or we are very short-sighted, I should say that. We are very
We are.
short-sighted. And I
We
think,
are.
yeah,
We can take it on the chin. Yeah. But if I could just get back to something that Corin said as well. Sorry, we're all interrupting. We're all excited about this. But Corin said something like super important as well, is that with litigation, you're only seeing the top part. You're not seeing the bottom part of that iceberg. But what I'm finding as well, and I don't know, please tell me if your experiences are the same or different, is that often, even when you're in court, the clients themselves don't often get to express how they're really feeling or get to say what they want to say. Because they're there in court, they're under cross-examination, whatever, they have to say the right thing. And there's a winner and a loser, but they never really, do they ever get a sense of justice out of it and feel good? Whereas in my opinion, with mediation, that's a space where you can actually say how you feel within that safe space that has been created by the mediator. So often, the satisfaction in mediation, because you can actually express how you feel without risking the case, is better than actually in a court where it's all formal and you have to watch what you say and you can't say and all of that. So that's just my sense and how I've been experiencing it from clients. And then also, as you said, Naazneen, attorneys are very short-sighted because we're thinking long, drawn-out litigation is great for fees and stuff. But as you said, you want to build long-term relationships with your clients, and your clients are going to want to have an attorney who's going to be able to resolve their problems effectively, cost-effectively, and quickly. And also, you've got a bit more certainty if you're mediating because both parties are in control of the outcome. It's not the mediator. The parties are deciding the outcome, whereas if you hand it over to a judge, it's the judge, and no one knows with the legal system as it is now. You know, and I know when we tell our clients, well, what are my prospects? Well, previously maybe this, now I'm not so sure. No one knows. But if you're mediating,
depends
you
on
have
the judge.
control. It depends on the judge. It depends on what side of the bed the judge is working up on this day, all of those things. But if you're mediating, you're in control to a certain extent of what the outcome is. And I think it's law students and members of the public don't understand that the mediator is purely there to facilitate the process. They have no control over what the outcome is. It's the parties themselves that do. And I think that's very attractive. It would be very attractive to me if I was a litigant.
You said, sorry,
Sorry,
Lisa.
Lisa.
Carry on. We just went ahead because
Yeah,
we
I
thought we
You
apologize.
lost
disappeared
you.
and we
My
just
connection
carried on.
is behaving like it's Friday, so but the recording isn't affected. You guys have still being recorded, so yap away. Yeah, I think I once we get started on this topic, I think they are the selling points are so obvious for mediation. It's like we are preaching or we are saying it ad nauseum. It's cheaper, it's faster. You're not traumatized by the court system. It's all of those things. But it's just getting people to shift. And that's why I think call me a purist, but and that's why my topic is court compelled mediation a good starting point because I'm a purist, so I would not define what goes on at court mediation. Okay, but I still think it's a good starting point because we've got to turn the minds of the masses. We've got to shift the gears. If they have to be the ones to tell the attorneys, look, I can't afford you, I want to mediate, they must be the ones compelling. Because ultimately, it's their stuff that's being resolved or going to be resolved. They're the ones that are going to be paying the mediator or paying the attorney. So I think it's only fair that as Naazneen said, one of your DDRs, part of the motto is to empower, to educate. So if we can go to courts and we can start to shift the minds of ordinary people to say, hey, do you guys want to sit here the entire day? No. Okay. What is mediation? What does a mediator do? And all of those things, I think the public education aspect is so crucial when we're doing the pilot projects because we to turn the minds of our colleagues, our attorneys, and even the advocates is like turning a warship. it's like it's slow and painful. But I think the nice aspect about having these things on the ground is that it will the people start to get, their awareness starts to grow, and they start telling the attorneys, look, we don't want to do this. We don't want to sit here because, for one, I think it's unethical that an attorney can call a client to court and just keep rolling over the matter, adjourning and adjourning and adjourning. And so the client maybe has taken a day off, maybe they've left the child with somebody, and for them it's a big thing to come to court, and they leave at the end of the day, especially with protection order matters, which are ripe for mediation, by the way. They leave without any resolution.
Yeah, especially the opposing
Yes,
side.
Naz?
Yeah.
Yeah.
Sorry, Lisa. Especially when the opposing side employs all these delay tactics with all these rules, bring in the rule 2315, bring in the irregular step
Yeah,
just to
and
buy
and
time.
you
It's
kind of
it's ridiculous.
understand why sometimes clients don't want to pay attorneys, because there aren't any results. So they're being billed month on month, or bi-monthly, and they legitimately ask, and I worked at two law firms, they ask for what? Why is the bill so high? Because you've been emailing, because you've been going to court to adjourn the matter. So you're charged for all that, but there's no resolution. So, to put it in a nutshell and not to hog the time, I do think court compelled mediation, or mediation happening at court level, is an excellent starting point. It's more than a good starting point, because we've got to turn the minds of the masses, never mind our colleagues. I think we rather let the clients turn the minds of our colleagues, rather let them call the shots and say, look, attorney, I don't want to mediate. Yes, Karen? I thought you did.
Oh, no, sorry. Just taking my hair out my face.
Yes, Justine.
I've got something to add to
Yes.
that if I can get the gap. Is that I think one has to bear in mind that there are some matters that actually do need to go to litigation. We're not saying that everything must be mediated. There are matters where we need precedent, where there are important public interest issues, all of those things. But just from my perspective, and I'm assuming, well, I can't make assumptions, but that my colleagues are on the same page, we know as mediators, not everything can be mediated. We'd love to, but there is time and space where
Absolutely.
things have to be litigated. That's the first thing. Secondly, I think as attorneys, and this is for the younger generation who are coming up and studying and all of that, I think it's not maybe for the older guard like us who are practicing and are set in our ways, maybe it's a bit late, but I think the tide is starting to turn with practitioners very slowly, but it is based on what I'm hearing and counsel, and there are a lot of counsel and attorneys who are also wanting to mediate, but they're struggling to with the opposition who doesn't want to mediate. So it is turning, but it's turning very slowly. Me personally, why it was such an enticing opportunity to come and join you tonight is because we're speaking to students. And for students and candidate attorneys to hear that there is something else and to understand what it is, that is where we can make a huge impact as well, not just on the ground, but to educate through this platform. Because, and I want to reiterate this, you are as much of an attorney if
Yeah.
you are
Yeah.
mediating than you are if you're litigating. Because there's this perception that if you want to resolve things and you want to mediate, you're not a real lawyer, but you are. I'm just putting it out there because I get that a lot and it pees me off. Okay. So, and you can make fees out of it because with mediation, it's not like in the CCMA where conciliation you can't attend with your client. You can make fees out of it. You're going in there, you're preparing your clients either so that they know what they actually want. There's a whole strategy that goes into mediation as well, and not a strategy to delay, but to assist the parties and assist the mediator to come to a resolution quickly or with preserving relationships. So attorneys can still make money and make fees out of it. And the quicker you turn those matters over, the more you can
Yeah.
do. So I really believe that attorneys can still make fees out of it. It's just that mind shift, because often we're finding resistance. Oh no, but now we're all going to sit around and sing kumbaya and we're not actually going to be able to bill, because then now the clients are just resolving it themselves. What do they need us for? that's not the case. So it's that mind shift as well. But for youngsters, you are still an attorney if you're interested in mediation. And there's a lot that still goes in that you're advising your client and looking after their best interests if you're mediating. And quite honestly, I agree with you, Lisa, that as an attorney who has a lot of ethical responsibility, I think, and it's me personally, I'm not trying to cast aspersions on the legal practice or anything. As an attorney, I think ethically, if there is a matter that's ripe for mediation, you should be advising your client, or not telling them to do it, but explaining all of their options to them so that they can make an informed decision, because that is your responsibility as an attorney always.
Yeah. I'd like to come in there with a few points. So, Lisa, you brought up domestic violence matters.
Okay.
So I have a very different take on that. I don't believe that all domestic violence matters are mediatable. Anything, in my opinion, where there has been physical violence or there is the threat of physical violence cannot and should not be mediated. I believe that the victim needs the protection of the court, and it should be given. If she or he, the victim, agrees to mediate, it can be done, but it's got to be done with a very experienced person who understands what domestic violence is all about. And the reason that I say that not all domestic violence, so number one, for me, there should be like almost like a triage type exercise done when somebody comes in for a domestic violence. So is there violence? Go to court, get a protection order. If you, after you've got your protection order or an interim protection order, you then want to mediate, fine, but you mediate within those bounds. If there's been certain other types of domestic abuse, like coercive control, emotional and psychological abuse, we have to remember that there's a victim. Now, I've got a client at the moment, for example, who is a victim. He's male, right? He's broken. I know for a fact he could never go into a mediation and sit in the same room with that woman. Okay? So can mediation still work? Absolutely. Not in the same room. You've got to do shuttle mediation. You keep the parties in separate rooms. So to those who are watching this video or watch it later on, you need to understand that mediation doesn't need to be in the same room. So if you've got a client who says, I'm not sitting in the same room with that idiot, I'm sorry, I'm not doing that, you say, okay, you don't have to. We can do shuttle mediation. Even on Zoom, I use Zoom for a lot of my mediations. And I put the parties in separate rooms because it allows the parties to feel safe. I can say anything I like to this person. The other person's never going to hear it unless I give my consent for it to be told to the other person. Then to work with that power imbalance is so important. And in domestic violence matters, that power imbalance is huge, absolutely huge, and has to be dealt with in a really, really delicate manner. And that is my only issue with the pilot projects that are happening at the courts. So there are various ones that have been going for quite a few years. I know Benoni Court has been operating for quite a long time. At the children's courts in Wynberg, there was a project going for, I think it's been going for 7 years now. The difficulty that I have is that so many of our courts don't have the infrastructure. Now, you're mediating a matter where there's two parties who are fighting over care and contact of a child. You're in a public space. Where do the parties go? I've heard about mediations taking place in the court kitchen.
Holy
That's
smokes.
not conducive. I promise.
No,
kitchen.
no.
It's happened to Naz.
I'm sorry, I can imagine.
Right? So that is not, it's not private. It's not confidential. You've got people walking in and out, coming to make coffee. It just is not
The
conducive
parties were
to
shouting at
mediation.
each
And that
other.
for me, yeah. So for me, that is my only concern about the court. If there is a court is going to direct the parties to another location where there are proper facilities where the parties can sit and do what mediation is meant to be, private, confidential, without prejudice, all of those lovely things, fair enough. But in a courtroom setting, they're already under stress, they're already under pressure, and now you've got somebody who's sitting down with them and saying, okay, guys, we need to solve this because it's going to be better for you, because you don't have to go to court, you don't have to wait here you don't have to come back, and they're completely overwhelmed. Rather say to them, guys, we can offer you mediation. Here's a place where you could go, where you can have your mediation done, and it's going to be quiet and private. It's just going to be the two of you. Hopefully, you guys can resolve your dispute. If you can't, you can come back to court. But I think there's got to be that clear distinction between court, where we're fighting, and mediation, where we're resolving conflicts. I think that's very, very important to remember. There was another point which came up whilst Justine was talking, and now I cannot remember it.
Ranting and
Go back.
raving. I don't
So
blame
I'll
you.
look it up.
Yeah. So I just want to go back to also things that Lisa said. But before I do that, I just want to make a random comment to Karen's ending there. You do not have supper in a boxing ring, just to get that out there. But coming back to, the pilot projects and the court annexed mediation that you spoke about, Lisa, I agree. It is a good starting point. But at the moment, I ask anyone, what is the value of the court annexed mediation in its current form? Because currently it's just a notice that you attach to your summons, your applications to say whether you agree or not to mediation. And if somebody wants to then go forward on that, what is the value of it? What is the next steps to take? There's nothing. So that is something that needs to be looked at because it has no value. It's the same thing as parties saying, okay, let's try to mediate or whatever. If you're filling in a notice or you're submitting a notice, you have to be able to act on that notice. And it currently just serves no purpose besides being a piece of extra paper that your client is paying you 350 to 500 Rand for to fill in again and attach to your summons. It's just an extra cost. We've had a client who they filled in a mediation and we thought that the matter could be mediated. So we asked them, we said, listen, you filled in this notice and you said your client is willing to mediate. Can we proceed? And they're like, oh no, it was a mistake. I'm sorry. We're not prepared to mediate. What is the process forward? How do you act on that notice? It serves absolutely no value.
I suppose the question then becomes, if we cannot rely on colleagues who also want to mediate and are of our thinking, how does one compel them to mediate? And I think the difficulty there becomes with individuals thinking, but hang on, mediation is voluntary, so you can't compel people to mediate. But that's not entirely correct either, because your participation is voluntary, but a court can say to you, and this is my take on it, and how we are going to be looking, and I'd like to just also speak about our SASLAW pilot project. But this is how I'd like to see it, is that the judges come and assist us. Yes, they have rules, and we know they're stuck with those rules. And it was my understanding, I attended a conference, KZN conference of mediators a little while ago, where the JP for, I think it was Gauteng, I'm not sure, maybe Naazneen, where they were looking at amending the rules potentially to make it compulsory. But for judges in the interim to start making costs orders or something, so that there is some sort of mechanism to make attorneys who are just doing this tick box exercise to actually say, right, you actually have to sit down with the mediator, and it's not for the attorneys to sit down with the mediator. The clients must sit down with the mediator. The attorneys can be there, but the clients must sit with the mediator, and the mediator in a pre-mediation, let the mediator explain in the presence of the client what mediation is. Then those clients can decide, do they want to continue with mediation or not? And if they do, then for the whoever's mediating to full feedback to the court, because we know mediation doesn't always work. We'd love it to work always, but it doesn't. But if the parties still genuinely participate in the mediation process and genuinely try and resolve it and aren't able to, then that should still be recorded somewhere so that the judge knows, okay, these oaks did try and resolve it. So, you know what, I'm not going to make a punitive costs order against them, or I'm not going to order costs at whatever scale. But where those individuals go and do the mediation and just kind of pay lip service to it, they should still be sanctioned with costs. How else do we compel them to do that? And getting back to it, you can be forced to sit down with a mediator. It's still voluntary because you can always withdraw at any stage, but you can be forced to sit down with the mediator initially with your client so the mediator can explain the process to the parties. Then it's continued participation, absolutely voluntary, and I believe that still maintains the sanctity of mediation. But you can be forced to sit down initially and listen.
I wholeheartedly agree with you. So in numerous other jurisdictions in other countries, mediation is compulsory. So in Australia, for example, before you can even issue summons it's actually an application, it's quite different there, but for a divorce proceeding or anything related to children, where children are involved, you have to mediate. There are exceptions, domestic abuse exception, but you have to go to a pre-mediation meeting, like you're saying, Justine. And if we could get that, where there have been one or two matters that's happened, I know in KZN in particular, where certain judges have looked at an application and gone, oh, here's a Rule 41A says we're prepared to mediate. Here's another Rule 41A that says we're prepared to mediate. Have you mediated? Have you? No. Cheers. Off you go. That should be happening. And then when somebody puts a notice that says, no, we don't mediate, that should be interrogated. Why? Give us proper reasons why, not just, oh, we don't believe this is mediatable. No, give proper reasons why it's not mediatable. And it is, I think, up to our judges to make sure that at this stage anyway. But I know there is a push at the moment. There are a lot of discussions. The Law Commission has been working hard on a project to actually make mediation compulsory, that for all matters. Certainly, that would then come in across the board. And obviously, there will be exceptions.
There must be, yeah.
Just because a court compels you to mediate doesn't take away from the fact that it's voluntary. Because, like you say, you can tap out. That, if you have to attend, for example, a minimum of 2 sessions, or you have to at least attend a pre-mediation session where the mediator explains what is happening and what mediation is about, absolutely, that I think will be first class if we get to that point, and the sooner the better, because us as litigators, we know, Gauteng, you apply for a date for a trial today. If you're trial ready today and you apply, you're going to get a date in 20. You're going to wait for 5 years and just sit
100%.
there, and your life cannot go on because you're waiting. Now, who in their right mind, if they're given option 1, 2030, option 2, tomorrow, no brainer. Option 1, one single person, a judge or magistrate, who could wake up on the wrong side of the bed, or on the day that your trial is set down may not be available because somebody died or somebody's sick or they had a motor car accident or whatever, and you then have to roll over. Now you've waited 5 years. Option 2, you are empowered to make the decision yourself. You and the other party, with a mediator saying, helping you to communicate with each other what your needs are and to actually understand your own needs, because very often people don't.
100%.
Not going to choose that option, but they don't know.
Yeah. But that's exactly it.
Yeah.
Yeah.
Thank you, Karen. I think that was very informative, but also for the benefit of the students that are considering, going into mediation that might view this. There's something that I said at the beginning of this, that I think that mediation needs to be ingrained from the start, or rather from grassroots level. And that is what the main issue is here, is that alternate dispute resolution is included in things like PLT. Once you've finished, learn your foundation of your laws. But this actually needs to be a foundation module, because this is something that people need to learn at the offset. This is what you should do in order to bring justice to your client. Whereas candidates are going into the industry thinking, okay, well, now it's a rat race. I've got to compete. I've got to prove myself. I've got to read all these laws. I've got to employ delay tactics, and I've got to be this pit bull if I want to go into the industry and be amazing and be successful. They're going into it with the wrong mindset, because instead of saying, I want to go in and I want to help my clients, I want to get them justice faster. So I think we need to basically conceptualize it. We need to be able to help people envision a legal structure that starts with mediation as a priority and not just as an option. So I think that's something that's very important to look at. And I don't really have the stats on and successes of the current pilot projects that are existing. But what I can say is that if we develop one model of mediation in just one area, because everybody is now operating in silos everywhere. They're adopting different approaches that might fail, might work, whatever the case may be. Yet the government needs to say, or the judiciary rather needs to say, listen, we need to have one model. We need to use it in this one place, this concentrated place. We need to tailor it. We need to adapt it. We need to troubleshoot it. And then we need to replicate it everywhere. So I think that is what we need to do.
Go ahead.
I think, sorry,
I'd like
just to
Justine to
comment.
tell us about
Yes.
the new project, because there's a new pilot starting, as I understand it, in labour matters.
Well, not in labour matters in general, just in the labour court in the Western Cape. We are going to be starting, well, not we, SASLAW, which is the South African Association for Labour Law. It's a non-profit organization. It's national. The Western Cape chapter has just gotten the sign-off from the National Committee as well as from the judiciary to start a pilot project there. So just if I could maybe explain a little bit about SASLAW to the students, because this is all, and who's watching, because this is where you can become involved. So it's a non-profit organization. It's there for the advancement of labor law. And it's open to anyone who practices or operates in that area. So trade unionists, HR managers, labor, or any lawyers, students. There's actually a special membership for students as well. So all you need to do is you need to be under the age of 35 if you want to register as a student. And you have to be enrolled as a full-time student at an institution. And then you get a discounted membership. I think last year's membership was 250 Rand for the year. And it gives you certain benefits. You can attend webinars, you can network. It's a really great organization to belong to. I've belonged to it since I've been an article clerk, and I found huge value in it. And if you want to look at it more, you go to the SASLAW website. It's all set out there. So it's a non-profit organization, but it also has a pro bono arm. And that pro bono arm has been running for many, many years. I think it was started when Bradley Conradi was the national chairperson. And what the pro bono arm does is there are 4 labor courts in the country, only 4. And each labor court has got a pro bono clinic at it. So the Joburg one runs, I think, throughout the week, or it runs for 4 days a week. The Western Cape one on a Friday runs the pro bono clinic. And then the other 2, Durban and the Eastern Cape, they've got different days. But what they do is lawyers, SASLAW members who are lawyers, volunteer their time and they come and sit in the clinic and they assist members of the public who meet the means test. So often there's CCMA sometimes refer individuals or whatever the case may be. And then you sit there and you assist individuals who cannot afford attorneys. So that's what runs currently. Okay. What we are finding, though, in the labor courts, and as you said, Corin, in the other courts as well, but the labor court's kind of a standalone court. It has the same kind of standing as the High Court, but it's very specialized, as you know. Because of the funding, the CCMA has had a massive cut in funding. They can't even appoint commissioners at the moment to arbitrate disputes. And everything runs through the CCMA to the labor court. So And then in the CCMA, it's a Commission for Conciliation, Mediation, and Arbitration. But in all my years of practice, I've never had a mediation in the CCMA. It is provided for in the Labour Relations Act, but it's always conciliation and arbitration. And it's a tick box exercise often because the employers aren't even obliged to come to the conciliation. So, but now we don't have funding to appoint mediators to arbitrate or do anything. So the wheels are coming off there, not for lack of wanting to do it, but because there's no money. And then on the other side, we've got the Labour Court, which has got such a huge backlog of cases that's kind of also coming to, so we've got this problem on both sides. So what we've done as SASLAW is we've said, the Western Cape chapter said, listen, can't we offer time, those of us who are accredited mediators, can't we offer time to come and mediate stuff? Because it should be, it's our culture in any event as employment labour practitioners, because that's what we're meant to be. It's meant to be part of our system, but it isn't. And there are a lot of us who are accredited mediators. Can't we help? Just as practitioners, I know, I mean, and those online may not know that there are practitioners who are acting as acting judges in the high courts and the Madge courts to assist with that backlog. Counsel are acting as judges to assist with that backlog. So it's happening in those courts as well, and it's happening in our labour courts as well. There are also practitioners who are acting as judges just to assist because the funding is drying up. And because of the backlogs, as they say, justice delayed is justice denied. So what we've done, just for the Western Cape chapters, we've said, we've approached the judiciary and we said, is this something that you'd be interested in, if we could do it? And we've gotten the Western Cape Committee signed off on it, the National Committee have signed off on it. And so what we're going to do is, it's going to be a pro bono project initially. So there's going to be, no one's going to have to pay for those mediation services, whether they are represented by an attorney or not. And we are looking at trying to work it from both ends. So to start with the backlog and look at which cases can possibly be mediated, so that where those are, let's get a mediator involved to try and resolve that, so that those can be resolved and moved out of the system. And then potentially also from the front end, where individuals are coming to the pro bono clinic with stuff like enforcement of arbitration awards or matters like that, can we appoint a mediator to try and resolve them and kind of work at it from both sides? So that's where we are. It's, as we said, it's a pilot project. We're looking at just 6 months to set it up and see how it goes. And if we get good uptake and if it works and if our stats show that it's working, then we're hoping to be able to move it to the other labour courts through SASLAW, obviously. And as I said, for the first 6 months, it's going to be pro bono. So we're going to be calling on our SASLAW members who are accredited mediators to also spend some time and volunteer their time. And the idea is that once they are on the panel, and what we're saying at this stage is we're wanting to be quite selective because we want it to work. We don't want everyone to come and say they're a mediator and then come and, because there are a lot of people who aren't actually properly accredited mediators who do more harm than they do. So you have to be a SASLAW member and you have to be DISAC accredited. That's kind of where we're starting. And then to call on our SASLAW members in the Western Cape, those who are, volunteer some time, and then they can mediate in their offices. You know, there is a room in the court where we can, speaking to what you were saying, Corin, offer some privacy so we can do it properly. But it could be, if you're taking up the matter as a mediator, this is what we're envisaging at the moment. You can then meet with them in your offices, mediator, you're a professional, you do it professionally, properly, so that this project works because it's going to be to the benefit of everyone. So that's where we are. We're hoping to start the project at the beginning of the new court term, which end of Jan, beginning of Feb next year. So there is quite a bit of it for us to still do, train the court staff, because we really are very committed to making it work and getting buy-in and to educate as well, because that's what we also hope, that by doing it and being committed to it and doing it really properly, not that the other court systems aren't doing it properly, but I'm just speaking about this little pilot that we are going to try and get going, is to educate the public as to what mediation is, to educate our colleagues as to what mediation is, because they may not know. Some of the judges don't even know really what mediation is and how that can be of benefit, and the court staff. So we're hoping to do it as help the backlog, but also use it as an education tool. And where students can become involved as well is, obviously there's it's a non-profit, and we're going to be doing it pro bono, so there's no funding. So if there are students who want to become SASLAW members, who want to come and assist and help us with the admin that is involved, or maybe even if they're interested in mediation, come and co-mediate, not co-mediate, they can't co-mediate obviously, but come and sit in with obviously the permission of the clients or whatever the situation may be, to get a sense of what it's like. And for those mediators who are SASLAW members and DISAC accredited, who don't have a lot of experience in mediation, because obviously we're going to have experienced mediators with the litigation stuff, but you may not have a hell of a lot of experience. We still want you to be involved, because you can then co-mediate and get experience. So that's the idea. We've got sign-off from everyone. Michelle and I are working on just getting the last little bits and pieces in place so that we can roll it out. And that's our vision for it. Yeah, and then we're going to see what happens. But if there is anyone who is keen, we're going to be reaching out to our SASLAW members to say, if you can, step up, come and help us and do this. And the idea is obviously not for it to be free forever. I mean, everyone wants to make a bit of money, but that's not the idea of this at the moment. It's to get knowledge and get education out there. And then if it comes off the ground, then there may be opportunities for others to now come in and mediate and charge a nominal fee, or whatever the case may be, just to assist, because that's really what we're wanting. We need to assist the court systems. That's very pie in the sky, I know, and very raw. But we're going to be practicing in these systems. If we don't help them before they fall apart absolutely, completely, we're going to be out of work.
Yeah.
Yeah,
I think that's what's so important is that, and I sorry,
I think that
I'm
Naz had a
interrupting.
hand up.
Sorry, Lisa, I didn't mean to interrupt.
Yeah, I did have my hand up, but I was actually going to pass the mic over to Karen, so to speak, because something that we identify with in terms of yourself is the mentorship. Sorry, Justine, the mentorship that you just spoke about, and that's something that's a very big part of DDR as well. So that's Karen's like baby. So Karen, mic over to you.
Yeah, so one of the from a mediator's point of view, I know that whenever I'm meeting another person who's a mediator, and I ask them how's it going, and one of the biggest things is I'm not getting any mediations. I can't
100%.
get in the door. I'm not getting, you have to have supervision. I'm not getting supervision. I can't. So
can't get experience to get the work.
Exactly. So for me, one of my passion projects, like Naz says, is, and if you go to Dignified Dispute Resolution to our website, which is ddrsa.co.za, you will see that we have a mentorship program. So the whole idea with the mentorship program is to get young mediators. They're not always necessarily young. Some of them start older in life, but newly accredited mediators who've just finished their training to come onto our panel so
That's
that
awesome.
when we get mediations, they can then sit in. And even if they're just observing initially, but to see what it's actually like in real life, because what you learn and what you practice are two completely different things.
100%.
Yes, you learn about, all the skills that you need, all the soft skills, active listening and all of those lovely things, which I think every lawyer should learn anywho.
Exactly.
Because, just to learn how to listen to another person is like,
I think we're all going to be blacklisted, guys, after this discussion.
So that for me, it fills my heart with joy to hear that you and Michelle are incorporating that into that pilot, because it is so, so, so important.
You have to.
And I think for me as well, one of the biggest things that really touches me is that the vast majority of our population are people of color, and there are far less opportunities for mediators of color than there are for mediators who are lily whites. And so for me, if you've got a conflict between, I mean, I've mediated, with people of all different, the rainbow, the whole rainbow. But I always ask, especially for example, Zulu people, they've got in their culture, mediation has been done in the Zulu culture for centuries. This is nothing new to Zulu people. And I always ask them, have you done traditional mediation or do you want to do it before we start the process? So to allow them that option. But we need to be culturally sensitive. I can't mediate a dispute, in all honesty, with people who are, from a colored community. Their whole culture is so different to mine. And to have mediators who understand that culture, have grown up in that culture, it just, for me, I believe, will get much more buy-in to mediation from those people, that I'm sitting with somebody who really gets me. So for me, that whole mentorship program is just like just makes my soul so happy.
It has to be, just from my side, maybe Corin, just to touch on two things that you've said, because I think for those who are watching who may be thinking of going into mediation or don't know about mediation, is what you've said is one of the core things about mediation, which is and I keep saying the safe space, which is, as we all know, it's the voluntary, without prejudice, confidential, all of those good things. But at the end of the day, you're only going to be successful as a mediator if those that you're sitting with trust you and you resonate with them. And that's what it's all about. That's what really, if you distill it to anything, I think that is what it is. It's that trust. And speaking to what you're saying about, I may be the world's greatest mediator, but those who I'm dealing with may not feel comfortable with a white person. It's not a judgment of you. You as a mediator have to be impartial, and it's about what do they need to get to where they need to be. It's not about you. You are just the conduit, and the conduit has to work for those parties to get to where they need. And as you said previously, sometimes those individuals don't even know what it is that is driving that need to be in dispute. That's part of your process as a mediator, to unpack those things. How are you going to do that if that person doesn't trust you? So that's it. And then speaking to that, and then the other thing is, as practitioners, and particularly thinking of this pilot project, we want it to succeed. It has to succeed. And I think for us as mediators, we want mediation to succeed. But then it's our responsibility to ensure that the mediators that are out there mediating and are carrying this title of mediator, which is, I think we all are very protective over, because it's such a big responsibility to be a mediator. They must be properly accredited. They must be trained properly, because otherwise they make a mockery of what we do, and they just take us back to step one. So it's a no-brainer that you have to mentor, because you want high standard, good quality mediators to be out there engaging with the public and showing what can be done.
I, Justina, 100% agree with you on that. And I think that's one of the core factors of how DDR was born from our side, is the fact that mediators, anybody from any type of background could do a 5-day mediation course and then call themselves mediators, whether that be someone who has absolutely no background of anything whatsoever, to people who are abusive husbands or abusive wives that are doing a 5-day course because they think that mediation can make them 12 to 15,000 Rand a day. Is actually a very dangerous thing.
Good
So
luck.
whilst wanting to make mediation mainstream, you have these, sorry, house executives that are listening to this, but that are doing 5-day courses and are trying to mediate matters that litigants have been trying to litigate for a number of years. And you're trying to grasp all of that into one session of mediation, which is absolutely dangerous. So becoming mediation becoming mainstream, also a core factor of DDR's responsibility is ensuring that our mediators were properly accredited, they come from a certain type of
Exactly.
background, and they're properly equipped to handle disputes of this nature.
And subscribe to the code of ethics as well that is out there. Because that is, I mean, that's completely separate. You can mediate, but I mean, and that's as law students and as candidate attorneys, we know that there's certain, the Law Society watches us, and there's code of conduct and the ethics that apply to attorneys, which we won't talk about. But at the same time, as mediators, I think the public don't know that as mediators, there's also a very strict code of ethics that we have to comply with. And even more so, sometimes in certain, because you're dealing with this really sacred space and this trust relationship, it's such a fine line between what you can do and what you shouldn't be doing. And even in those side meetings, Corin, that you mentioned earlier, where it's what you tell me is confidential and I will not disclose it to the other side unless you give me specific permission. But you as the mediator know that if the other side knows what this person has told you, it could potentially resolve the dispute. But you cannot disclose that because that individual has not given you permission. And that kind of ethical dilemma, you have to have experience and you have to have proper training, and also you have to have colleagues to bounce these things off, just to get input so that you can do the right thing and you yourself can grow, even though you've got years of experience. And I think that, as you said, the two of you said, is what's lacking as well, is where mediators can, amongst colleagues, also just meet and say, listen, not disclose who and that, but I've got this really tricky situation and I'm thinking of doing it this way, but I'm not sure. And so also to guard against that, where we don't share our knowledge because we're so caught up in we need to find work to sustain a mediation practice, because we do that as attorneys. Right? We don't want to share anything because we need to bill fees and this is our practice and we can't engage. Obviously not sharing information, but just experiences. I think that's also something that to explore. I mean, I'd love to hear from you and what your organization does in that, and maybe we could do some sort of collaboration because we're talking the same language, it seems, and we believe in the same thing.
Yeah. I think one of the points that I just want to make that for me is one of the most problematic things in the mediation space at the moment is that, yes, there is DISAC, there is a code of conduct, but there is no regulatory body.
Yeah.
And that for me is extremely problematic. We have to have a regulatory body where if a mediator crosses a line, steps can be taken by the regulatory body, like the LPC. We won't go into that subject. Like the LPC is there to regulate legal practitioners. Okay, there needs to be regulation. Now, I know it's on its way, and that's a great thing because that is so necessary. And it was one of the reasons why when we started DER, we've got our own code of conduct. And if somebody comes to us for a mediation and then they say to us, that mediator, cuckoo, we will investigate that ourselves, and that person will be off our panel for sure if we find that they didn't. So that is the difficulty. And like Naz says, at the moment, anybody can become. You can be a hairdresser, a truck driver, whatever. You decide that's not satisfying you. You're going to do a 40-hour mediation training course compared with somebody who's done, a 4 or 5 or 6 or 7 year degree and has got 4 or 5 or 6 or 7 or whatever it is years experience. Now suddenly, last week you were cutting hair. This week you've got a little certificate that says you're a mediator, and off you go trotting to the court, and you go to the magistrate and say, mediator. And it's being allowed. That is the scary thing. And that's where unfortunately, there have been reports of where matters have gone completely pear-shaped. And that, unfortunately, gives the profession, because it is it needs to become a profession. It gives the profession a bad name. And that therein lies another one of the obstacles we have to, as experienced and trained mediators, overcome, is to weed out the wheat from the chaff, if you will, to make sure that those who are mediating really do have the credentials to do it and are not just, like Naz says, some board housewife who has got an unfulfilled marriage and her children have flown the nest and all of a sudden she's looking for something else to do. The one thing, Justine, I wanted to say on, us all wanting to hang on to our piece of the pie. Our justice system is falling apart. We know that. We all know that. The backlog is just utterly ridiculous. It's a breaking point, and the place it's going to break to is mediation, is alternate dispute resolution. It's got to have an outlet. When that bottleneck explodes, and it's about to, it's going to explode into mediation. So why should we be embracing mediation? Because we are going to become busy. If we all let go of that concept that we can't make money because we're hanging on to our little piece of the pie, I mean, if I've got a mediation or a matter that I know I can't mediate it, I'm going to refer it to a specialist like Justine, for example, because she's a specialist in a particular area. If we all start taking that mindset and we have that type of, we're all going to make loads of money. We don't have to stress about that because the work is there. We just have to, we're waiting for the bottleneck to explode and that work is going to come flooding. But we need to be ready for it. And like you say, we need to work together to get that to that point.
You see, my concern, and I completely agree with what you're saying, that there is huge opportunity coming. My concern, personally, and maybe it's just in the space in which I practice, and once again, it's in the employment labor courts, which is very different to where you practice. My big concern is that when that falls apart, because there hasn't been an uptake in mediation up to this point, that it's just going to be complete chaos. And that's my concern, because there's going to be a gap before anything happens. And what happens to the public who need access to the courts and who need assistance? And I'm being very selfish because I'm thinking about the labor court. What happens when the CCMA completely starts working? And it's close to it, not because they don't want to, but because there's no funding, because it's like all of the other systems. The judges on the bench are fantastic, but they can only do so much. My concern is what happens when it stops. And that's why I'm appealing, not to you because I'm talking to converts, and you guys, I mean, we're speaking the same language, but to anyone who's watching, who's thinking of coming into the profession, who wants to help, please help us to help the system. Put your hands up. Do something to help us stop this thing from falling apart completely and reaching a point of no return. Because it's like Eskom. We were all worried because what happens when the whole grid collapses and we don't have any electricity? We're not going to come back from that. And that's my concern for the labor court at the very least. Because how do we come back from that? When it's completely broken. We're not going to. And that's what what we're hoping with me, and I'm speaking purely for myself, I'm hoping with this pilot project is to at least make some inroads so that we can get a bit of momentum to help the courts and to help, because in helping the courts, we're helping our fellow citizens. So that's just my final plea. I don't know where we are in the time, but for anyone who's interested, just please help just come and help us. Roll up your sleeves. You don't have to give a whole lot of time, but just do something to help us. And yes, and there will be a lot of work for everyone, 100%. I've got no doubts about that. But what do we do in the meantime when there's absolutely nothing? When the lights are completely out and we're all in darkness?
We've got about 8 minutes. So many points I want to touch on, but I think one that's come out fairly strongly, and I think it gets misrepresented, is that, and what Naz has touched on, is that you don't become a mediator overnight. You can't say it's the easier than doing an LLB. Rather go to the 40-hour factory, as some people call it, and become a mediator. If anything, I think it requires more trust than being an attorney. I think you really get to know people in the process of mediation. There's just, I think, I dare say there's a whole other set of ethics that's involved compared to the legal profession, because you're dealing so closely with people, that
100%.
man, you've got to be trained properly. And for me, and I know that I want to put it out there that there are two camps. That one that believe, no, you just do it naturally, it's a natural talent, you're helping people solve problems. And indeed, that's the way I've pitched it, to get people
Mm-mm.
interested, because it's such a sacred trust, number one. And number two, because you want to make a living. So you're going to be collecting money from people. They're going to be paying you to help them facilitate a resolution. I think, if anything, for those two reasons, you've got to be you've got to you've got to be well produced, you've got to be experienced, you've got to be accredited, you've got to be trained. You can't come out with a piece of paper and hope to make, as Naza said, out of 15,000 rand a day, which again is another fairy tale. So I think for students, law graduates out there, yes, it might look like an easier path to getting work, to getting into some kind of dispute resolution setup, but it's not necessarily, like I say, with candidate attorneys who want to do it, is not the easy alternative. It's not the, oh, I don't want to do an LLB, so I'll do a mediation course, or I didn't get articles, so I want to become an advocate. It's a whole other mindset, and you've got to take it seriously. You've got to be accredited. And the thing is, the more of you that do that, the more people do that, as Justine very soberly reminded us now, we could just have the bottleneck could just explode, and it go all over the place, and there's no one to catch it. So we want a proper understanding of mediation. We want, and I'm, of course, this is a mentorship group, so it's so encouraging to hear that part of the pilot, at the labor court, includes mentorship. DDR includes mentorship, because we have to encourage the practical side of things. We cannot mediation, like litigation. We can lecture you on trial advocacy, we can lecture you on active listening, but unless we've created a safe space for you to see it in action, you're not going to feel brave enough or safe enough to say, I can do that, or maybe I need to sit in a few more before I actually feel confident. So I'm really pleased with the mentorship side of things, and I hope that more things come up that include mentorship in the mediation space specifically. I think before I wrap up, maybe I'd like to give you ladies some last thoughts you want to insert in before we can wrap it up for the night. Who's done the least talking? I think now.
If I could,
I think we've had a, I
the
think
most,
our conversation went all around like this. Lisa, when we lost you,
you
we
missed
we
some
took the
good
whole,
stuff, Lisa.
we got some good stuff in, yeah. But thank you to all of you ladies for the opportunity, and Lisa for this initiative, because we need to be having more conversations like this, and we need to be having them regularly. And not just for like young legal professionals, but for the general public to be watching these things, to understand what mediation is all about, because the people, like to say, if they know and they say, hang on, I can pay my attorney 250,000 rand to go to court in 5 years time, or I can pay this mediator whatever it is, 10 or 15 or whatever it's going to be, and get this resolved in a week. I'm going to go this side, guys. Then mediation is really going to get the traction that it deserves, and people will get the justice they deserve. That's the most important thing.
Justine? Oh, okay. Nas, you go.
Yeah, I think
Could just add,
from
yeah. Sorry, Naz, go
sorry.
ahead.
Yeah, from my side, when people ask me, are there any final points, and I come up with some random catch slogan that comes from nowhere, I think all I gotta say is there's 100 points that can be actually added on as final points, because if we can sit the whole day, we can talk about mediation and the disputes and stuff the whole day. So I think, yeah, that's just from me. But I'd like to thank Lisa for inviting us to this discussion, because I really think that it's much needed.
Justine?
Thanks, Lisa. Once again, yeah, it was awesome. And also thank you to Corin and Naz for sharing so openly. And for us, it was I really enjoyed it. I must say, I hope anyone who watches this does enjoy it as well, as much as we did talking about it. But just one thing, maybe that's for students who are not litigating and all of that, and who are listening to all of us and we're saying, yes, you need to have experience. It's not just to have the 40-hour certificate and all of that. It's like a driver's license. You get the driver's license and you're allowed to go out onto the road, but it doesn't mean that you know how to drive. Okay, often. And that's exactly what that accreditation is. You've got the basics. You maybe know how to park, parallel park, but when you're out there on the road doing a long trip and things happen and, that's what it's like. And that's why we so reach out, anyone who's interested, reach out to SASLAW, reach out to Corin and Naazneen, look at their website. We'd love to engage with you. We'd love to involve you where we can. And we need people to come and join the fight. Join this to keep things rolling forward for everyone and to make sure that others get justice. It may not be justice through litigation, but justice is still there to be
Thanks,
achieved
Justine. Yeah,
in other ways.
yeah. I think if there's one
Well said.
fight you want to get behind in our industry, is this, because it will pay off in the long run. And as Michelle said in our last panel, we're almost there. We're almost there. So the more people we have putting their shoulder to the wheel and pushing this thing, we're almost at the top of the hill. And we don't want people's issues to fall through the cracks. We don't want one more person, going to bed with a dispute just unresolved or sitting in the court system and it looks hopeless. Ultimately, we want society to be as whole as possible. And I think mediators play a huge role in that. We don't just give people the answer, but we give them the space to find the answer for themselves. And of course, in finding the answer for themselves, they are actually able to maintain a certain peace going forward, so that they're not continually dependent on a mediator. And then of course we move on to the next person and we just sort of change society one dispute at a time. So thank you again, ladies. I'm really glad we managed to pull this off. And of course, this won't be the last. I think once my group takes off, I'm sure you guys will be, since we're all dealing with mentorship in our various spaces, I'm sure that there'll be sort of interrelations or just supporting each other, coming alongside each other, piggybacking off each
Definitely.
other, because I think the mediator crowd is such a crowd that we just love to share. So thank you to everyone who's been here, Karen, Candace, and anybody else I can't see, and of course for those that watched the video and you last till the end. Well done. So thank you so much, ladies, and have a good weekend.
Thank you. Thank
Thanks,
you very much.
everyone.
You too. Bye, Corin. Bye, Naz.
Bye.